I am not biased. I may have signed a search warrant that met probable cause for them to be able to search. You are innocent unless the state proves you guilty. That is their burden and their burden alone.
This hearing gets intense fast. The defendant insists the judge is biased. The judge fires back defending her impartiality, and both sides clash over a $10,000 cash bond. To make it worse, he's been sitting in jail for a month with no attorney. Watch how this courtroom turns emotional and explosive.
Mr. Jones, you got to hit a button or do something, I think, because there you go. Okay, Mr. Blahowski. Mr. Blahowski.
Yes.
You
yes,
qualify for a public defender now, don't you?
Yes, I did, and I still haven't got access to any defense counsel.
That is totally fine. And so what I'm going to do here today is, again, we can push your adjourned initial appearance to another date, but I will hear you on bond again.
Okay. Are you ready?
Just wait. Nope. Let me call the case.
Okay.
We will go on the record in the matter 25 CF 152, State of Wisconsin versus Daniel Blahowski. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Blahowski, who's appearing by video conferencing in custody in Burnett County Jail. He was set today to be here or for an initial appearance. However, he qualifies for a public defender. The public defender has not yet been able to appoint an attorney for him. Mr. Blahowski, it must have been recently, like between November 5th and today, or except November 5th to the 18th, in which you then qualified for the public defender and reapplied. Is that correct?
The defendant hasn't spoken to a single lawyer in over a month. That's a serious constitutional concern, and courts don't like delays that block someone from defending themselves.
That's not correct, Your Honor. I qualified on October 18th of 2025 by phone with the public defender's office and was ordered to pay $60. And that was on October 18th. So it's been over a month and I have got no representation at all. And I've been sitting in jail.
That is correct. I don't have an attorney here right now to see about whether or not they could accept the appointment. I do have the attempts. They've only made 77 attempts at this time to locate an attorney for you. But because you've been in custody for this length of time on a $10,000 cash bond, and they have not yet been able to appoint you an attorney, I will hear you on bond, and it's getting to the point where the court may have to look at court appointing or instructing the public defender's office to do a little bit more action. Mr. Blahowski, I will allow you to be heard on bond. You may go.
77 attempts to find him a lawyer is wild. At this point, the judge is clearly frustrated with the public defender's office and is hinting at forcing action.
Yes, Your Honor. For the record, there was a bond reduction hearing that happened on November 5th on my initial appearance date in lieu of the initial appearance, and the district attorney brought up my previous record, which was charges for possession of stolen property in 1981, 44 years ago. Up to 1985, there was some welfare fraud and some other stuff, and he deemed me dishonest, liar for them charges, even though, you know, I guess somebody can't change after 44 years. But I'd like the court to know that I have not been in front of a judge, be it criminal, civil, or traffic, for 25 years. Since the year 2000, and the district attorney did note that on the record on my last appearance. And I do own my home, a 40-year-old trailer house here in Burnett County, Wisconsin, and I've been a permanent resident for 4 years. I'm 64 years old and I'm disabled, and I'm not a flight risk. And I would like Your Honor to take into consideration these facts and the fact that I promise, Your Honor, that I will abide by your directives and your conditions of release. And I will make all my appearances on this matter until it's completely resolved. And I understand your need to protect the public and witnesses and stuff in this case, but you have my word that I won't do anything. I'm on disability and my payment stopped after 30 days. So I don't have any income as of now, right now. And I would ask Your Honor to reduce the $10,000 cash bail to make it possible for me to mount a defense against this. And I'd like to remind the court that I'm presumed innocent until proven guilty beyond a reasonable doubt by a jury of my peers. But I feel as though my last hearing, you brought up all the charges against me, and in the same breath, you declared every maximum sentence against me.
His argument hits hard. No income, disabled, stable home, and no record for 25 years. These factors usually help in bond decisions, if the judge believes him.
And I feel I've been adjudged guilty by the sitting judge on this case, and you also endorsed the search warrant on this case, and I don't see how you could even say that you could be impartial to this hearing or any future hearings
I
concerning
am
this
going to
matter.
stop you right now. I'm very impartial. I am impartial. I am not biased. I may have signed a search warrant that met probable cause for them to be able to search. You are innocent unless the state proves you guilty. That is their burden and their burden alone. When we had the last hearing, I'm hearing you recite some things that are very inaccurate. When we had the last hearing, I do have to go over the charges that are charged against you. I do have to go over the maximum possible penalties. I do have to look at your history. I do have to look at, and the fact that it's so many years ago, and I understand that, and I believe that, and that goes into the positive side of your character. I went over all of those things, the fact that you've lived here for a long time, you own your home, you are alleging you won't be a flight risk, all of those factors, the things that you're saying that you're going to abide by the bond. However, I do have to take into account the facts that reach at least the probable cause level, which you've already reached in a search warrant, you've already reached in the criminal complaint. Now, whether it's going to be probable cause for felonies, I don't know, because we haven't had a preliminary hearing yet. It could go one way, it could go the other way. I have to look at all of the things when I'm setting bond. It's not just whether or not I think you're going to appear for court. However, in looking at whether or not I think you're going to appear for court, not only do I look at those factors, but I have to look at what you face and the possibility that there could be, because we have Class E felonies here. There's 2 Class E felonies. Maximum penalty is 15 years of incarceration each. And then there's 2 I felonies. Maximum incarceration could be 3.5 years each, plus those misdemeanors. I have to look at all of those factors. That's my job. I am not.
The judge pushes back strong. She explains every bond factor, felony exposure, and why she must review past charges. This is a textbook breakdown of judicial impartiality.
Bias. I am impartial, and I'm going to tell you there have been many cases similar to this that I have thrown out. It all depends on the facts of the case and how it washes out in the course of the matter. And the fact that I'm allowing you to argue your bail request multiple times should show you I'm impartial, because I'm listening to hearing you instead of just saying, nope, you're going to sit there. And the fact that I'm looking at now, I need to look to either push the public defender's office harder to try and find an attorney that can represent you, or I need to do a court-appointed attorney, okay? Those are the things that I look at. I'm here to protect your rights as well as the rights of the public.
Okay, Your Honor, thank you for specifying that. I am not an attorney and I wasn't aware of that, and I respectfully apologize to the court for my actions.
I don't need an apology, Mr. Blahowski. I understand where you're coming from. You're in a place where you're in custody with very serious charges. You have not yet had an attorney appointed to you. I get that, and that's why I'm here to listen. Do you have anything else that you want me to know?
No, Your Honor. Thank you.
Mr. Schmidt.
I think the bond should remain where it is. I think what the defendant's confusion about is what the court is supposed to consider for setting bond is likelihood to appear, and what the state argued last time, what the court uses its basis of its decision last time, was the fact that when a person has a great deal of exposure, and the allegations at least purport to have a great deal of very strong evidence, that is, there's a higher certainty of conviction on those very high penalties, such as in a case where it's, multiple controlled buys into a single individual. That's something the court can consider in setting a cash bond. I think the court already did consider a lot of the positive factors Mr. Blahowski has articulated in setting the $10,000 cash bond. We've seen other people who also have multiple controlled buys into them with, $20,000, $25,000, $50,000 cash bonds. So I think he's also already has that benefit. The only new factor I've really heard today is that the defendant owns a home, which I think means he actually could raise the money to post this bond. So I'd ask that the bond remain the same. Thank you.
Well, and that's where I was going to go and ask him about his home, because I did catch the fact that he's owned it for 40 years or something, some long time, and it's a mobile home. And so I need to know if there is, do you have equity in the home? How do you own that home?
No, Your Honor, I bought it for, it's a 1971 mobile home. I bought it for $2,000, and I moved.
That's all I need to know. And it's on it's in a park or something?
It's on a lot, and I am 3 years into a 7-year rent-to-own contract for the 0.47 acre lot that it sits on.
Okay, all right. And Mr. Blahowski, I do need to hear all of these things. I mean, quite honestly, with the owning the home, that kind of goes with it being the mobile home, and all of those things kind of goes on the other end, because it's less property that you can leave if you wish to do so. However, I am going to tell you that being in custody for a month and not yet having an attorney appointed to you, that weighs heavily in my decision here, because you have a right to be able to defend yourself, as well as, gather evidence.
A month in custody with no attorney finally tips the scale. Courts take due process delays seriously. His rights can't wait forever.
So I am going to amend bond here today, simply because I want you to have the ability to be able to post and get out of custody, especially if you're not able to have an attorney to represent you, at least at this time, because the longer it takes for you to get an attorney, the harder it is for you, and the more that the court has to look at your constitutional rights. Although I'm not going to do a signature bond, because again, these are very serious allegations, and there are facts here alleged with a confidential informant. You're correct, though, that looking at your 44-year ago criminal history is something, and again, that goes in your favor, that there has been a span of time that you have not engaged in any criminal conduct, at least that is brought to a court's awareness. But then again, the court has to look at these serious charges and the fact that they are here. But you are innocent unless the state proves that you are guilty beyond a reasonable doubt. I'm willing to modify bond, but I'm willing to modify bond to $2,500 cash with the same conditions. Again, it's simply because you have the right to be able to bail yourself out, especially in light of the fact that you do not have an attorney yet appointed to you to help you in the course of this matter. I'm glad that the public defender's office is now looking, and hopefully looking vigorously or more vigorously for representation. I'm going to reset your case. But I'm trying to find a good time to be able to do that. Reset your case for 9:45 on December 8th, 9:45 on December 8th.
Okay, thank you, Your Honor.
All right, thank you. We are adjourned.
The judge slashes his bond to $2,500, giving him a real chance to fight his case. A big win after weeks of waiting. What do you think? Fair call or risky release? Tell us in the comments, and don't forget to like and subscribe for more courtroom breakdowns.